So once again, good afternoon, everyone. So our topic for today is about labor relations and collective bargaining. To be presented by Sir Joseph Mercado. So in the public sector, so take it away, sir.
Thank you very much, Dean. Good afternoon, classmates. So, today we will be discussing labor relations and collective bargaining. So, first, let's know what are the uh, basic rights of labor workers. Spread in a various parts of the 1987 Philippine Constitution are specific pronouncement and mandates of the protection and promotion of the rights of workers in the public and private sectors. To wit, Section 18, Article 2, the state recognizes labor as a primary social economic force and it endeavors to protect the rights of workers and promote their welfare. Section 8, Article 3, the state recognizes the right of workers in the public and private sectors to form unions. Section 2, Article 8, the state pronounces the promotion of social justice as one of its main goals. Some of the most specific labor-related provisions of the Constitution is found in Section 3, Article 8 thereof, which provides that the state shall afford full protection to labor, local and overseas, organized and unorganized, that the state shall aim to promote full employment, that the equality of employment opportunities for all shall be respected, that the state shall protect the right of all workers to self-organization, collective bargaining and negotiations, peaceful concerted activities, and including the right to strike in accordance with law. In addition, that the right to secure of tenure of workers shall be respected, that the workers are entitled to humane conditions of work, entitled to a living wage, that the workers shall be afforded to the right to participate in policy and decision-making processes affecting their rights and benefits as may be provided by law, that employers and workers must be guided by the precept of shared responsibility, and that the state encourages the, the preferential use of voluntary modes in settling disputes, for example, reconciliation, mediation, and voluntary arbitration, and that the state has the power to regulate the relations between workers and employers, that the state respects the right of labor to its justice to just share in the fruits of production, and lastly, the balancing capital with labor. The state recognizes the right of enterprises to reasonable returns on investments and to expansion and growth. Union Employees Organization. It refers to any labor organization organized for collective bargaining or negotiation and for other legitimate purposes. In the Philippines, there are types of unions there are two types of unions: the public sector union or public employees organization, which refers to any organization, union, or association of employees in the agencies of the government which exists in whole or in part for the purpose of collective negotiation or mutual aid, interest, cooperation, and protection. Private sector union or labor organization, refers to any union or association of employees in the private sector which exist in whole or in part for the purpose of collective bargaining or mutual aid, interest, cooperation, protection, or other lawful purposes. Labor organizations are further classified into two: the formal and the informal organization. Formal labor organization refers to an organization with employee-employee relationship and is also known as enterprise-based unions. Excuse me, sir. Continue. My apologies. While the informal labor organization refers to organization with no definite employer. Workers associations. Workers associations are associations of workers organized for mutual aid and protection of its members or for any legitimate purposes other than collective bargaining. So as of 2018, a total of 84,878 labor organizations with more than 4.6 reported members are organized in the country. So for private sectors, we have 17,715 unions, 1.5 million report with 1.5 million reported members. For the public sector, we have 1,630 unions and half a million members. For workers' associations, we have a total of 64,930 associations with a total of 2.7 million reported members. Rights of legitimate labor organizations. For the private sector, pursuant to the Labor Code of the Philippines, the rights of the legitimate labor organizations are mentioned in the Article 242, which summarize as follows: undertake activities for the benefit of members, sue and be sued, exclusive representative of all employees, represent union members, furnished by employers of audited financial statement, own properties, and accepted from taxes. Rights of union members in an employees organization, according to Article 241 of the Labor Code and Rule 3, Section 1 of the Executive Order 180. The, the right to, or its political right, deliberate and decision-making right, rights over money matters, and right to information. Another one is from Article 243 of the Labor Code, to form, join, and assist labor organizations for the purpose of collective bargaining through representatives of their own choosing, and to engage in lawful concerted activities for the same. One of the classic example of uh, uh, such disputes or rights being practiced was the company Hoya Glass Disc Philippines, where 2,600 workers lost their job, and Hoya closed the company to avoid incurring losses. The other one classic is the Nestle Philippines, with 600 workers that went on strike, 23 strike related deaths, which settled in December 2013. Employees' right to self-organization on the public sector. In accordance to Section 1, Executive Order 180, all government employees can form, join, or assist employees' organizations of their own choosing for the furtherance and protection of their interests. They can also form labor management committees, work councils, and other forms of workers' participation schemes to achieve the same objectives. Strike. Strike, as defined by law, means any temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. A labor dispute includes any controversy or matter concerning terms and conditions of employment, or the association or representation of persons in negotiating, fixing, maintaining, changing, or arranging the terms and condition of employment, regarding of whether the disputants stand in the proximate relation of employers and employees. In one of the uh, classic example that shows the right to strike is the is the case about social security system employees versus the Court of Appeals. That is based on the Supreme Court reports annotated 686 in year 1989, which says that employees in the civil service may not resort to strikes, walkouts, and other temporary work stoppages, like workers in the private sector, to pressure the government to accede to their demands. Uh, ito po yung kumbaga naging precedence na na nagpabawal na dapat yung mga empleyado sa pamalaan hindi sila nagre-resort sa pagpapahinto sa pag-i-strike na makakapagpahinto ng serbisyo ng pagbibigay serbisyo ng pamahalaan. As now provided under Section 4, Rule 3 of the Rules and Regulation to govern the exercise of the right of government employees to self-organization, which took effect after the instant dispute arose, the terms and conditions of employment in the government, including any political subdivision or instrumentality thereof, and government-owned and controlled corporation with original charters, are governed by law, and employees therein shall not strike for the purpose of securing changes thereto. In government employment, however, it is the legislature where properly given delegated power, the administrative heads of government which fix the which fix the terms and condition of employment, and this is effected through statutes or administrative circulars, rules, and regulations, not through collective bargaining agreements. Other one is the Jacinto et al. Versus Court of Appeals et al., which states that moreover, the petitioners here, except Melinda Jacinto, were not penalized for the exercise of the right to assemble peacefully and to petition the government for redress of grievances. Rather, the Civil Service Commission found them guilty of conduct prejudicial to the best interests of the service for having absented themselves without proper authority from their schools during regular school days in order to participate in the mass protest, their absence ineluctably resulting in the non-holding of classes and in deprivation of students of education for which they were responsible. So it had petitioners availed themselves of their free time, recess, after classes, weekends, or holidays to dramatize their grievances and to dialogue with the proper authorities within the bounds of law. No one, not even Dex or the CSC or even the court could have held them liable for the valid exercise of their constitutionally guaranteed rights, as it was the temporary stoppage of classes resulting from their activity necessarily disrupted public services. The very evil sought to be forestalled by the provision against strikes by government workers. So, ito yung sinasabi ko kanina na kumbaga ah kung sakali no hindi naman sila pinagbabawalan na nailabas yung kanilang grievances. However, should they chose to do it to present their grievances during the time na hindi naapektuhan yung serbisyo, pangunahing serbisyo na binibigay na law for which in this term is yung education. So hindi sana sila makakasuhan o hindi sila magiging held liable sa pagpapabaya. So here are the difference between uh, the rights to self-organization in public versus the public sector. So kung mapapansin natin, there are uh, a lot of difference uh, in terms of self-organization in the public and the private sector. So, technically, in the public sector, we do not have the right to strike. Hindi katulad ng sa private sector wherein uh, yung strike could hamper the operation ng mismong company. So, dun sa nabanggit na kanina na kaso na naipresenta, sa public sector, hindi siya pwedeng gawin. So, kumbaga, hindi siya uh, 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 technically, government employees do not have the right to strike, especially kung maapektuhan yung serbisyong binibigay ng pamahalaan. So, right to bargain. The basis ng right to bargain is for the public sector is although meron siya pero limited bargain rights lang. So yung terms of employment not fixed by law, which is according to section 13 executive section 13 executive order of executive order 180. So however, sa private sector, they have unlimited bargaining rights. So kumbaga uh, anytime kumbaga pwede silang makipag-bargain. Sometimes yung mga yung mga employees organization when they uh, kung uh, kung sa tingin nila yung kumpanya ay kumikita, they could, if they want, na makipag-bargain, kumaga mag-enter into another bargain agreements. For the purpose of organization, the public sector can only form, join, or assist labor organization for purpose not contrary to law. While in the private sector, the private gov- uh, excuse me, employees in the in the private sector can form, join, or assist labor organization for purposes of CBA, etc. Persons or employees who are not granted the right to self-organization. So the high level or managerial government employees, which is stated in Section 3 of Executive Order 180, employees of international organizations with immunities with legal basis on International Catholic Migration Commission versus Calleja et al. Managerial employees under Article 245 of the Labor Code, whose functions are normally considered as policy making or managerial. Franklin Baker Company versus Tarhano, whose duties are of a highly confidential and highly technical nature. Civil Service Commission versus Javier. Also, AP personnel including police officers, firemen, and jail guards are also not granted the right to self-organization based on Section 4 of Executive Order 180. Confidential employees based on the San Miguel Corporation Supervisors and Exempt Union et al. Versus Ledesma et al. Employees of cooperatives who are its members. San Jose Electric Service Cooperative Incorporated versus Ministry of Labor. So doon naman po sa mga non-employees, Rosario Brothers versus Ople. Segregation of rank and file employees and supervisors. According to Article 245 of the Labor Code, managerial employees are not eligible to join, assist, or form any labor organization of the rank and file employees but may join, assist, or form separate labor organization of their own. So it is based on the amended as amended by the Section 18 Republic Act number 6715 March 21, 1989. Conflict. Conflict is a situation when the interests of one or more persons of a group or groups are seen to be in opposition to the interests of some persons or groups. Exists whenever people are in disagreement and opposition. Examples are interpretation or violation of rights arising from law or from contract, differences over the interpretation or relevance of data, differing ideologies, religious beliefs, and cultural norms, breakdown in communications and understanding. So conflicts, as seen in the graph, is conflicts are costly the longer it lasts. the the longer it lasts, so mas malaking gastos. Kumbaga, this is according to the F. Stedman Handbook on Alternative Labor Dispute Resolution. Conflict management style. So, uh, based on leisure and hand-on human resource management. So, we have uh, the conflict management style that are basing on the needs for others, the needs of others and own needs and own needs. So which can uh, be accommodate, negotiate, collaborate, avoid, or forced. Effective dispute resolution. Union in private and public sectors. So according to 2008 Labor Dispute Resolution System in Asia Pacific region by Attorney Bitonio Jr., Employer and Labor Relations. So effective dispute resolutions are strikes, lockouts, adjudication, arbitration, mediation, negotiation. Negotiation. Negotiation is a process by which two or more parties seek to exchange with each other or among themselves things that they respectively value under terms and conditions mutually acceptable to all concerned. An approach at preventing or resolving conflicts resulting in an agreement or consensus of the parties. What can keep parties from negotiating? So, number one, the principle of economic rationality and self-interest. So, it is based dun sa kumbaga me first. So, usually, yung prinsipyo ng pangangailangan, ng needs. So pinag-aralan natin 'yan, yung kumbaga yung katulad ng diniscuss sa Maslow's hierarchy of needs. So kumbaga merong mga needs tayo na kailangang ma-satisfy and which kung titignan natin, uh, most of them centers to ourselves. So number two, in an employment relationship, this can translate to conflicting objectives and interests. So sometimes, kahit na lumalaki yung profit ng mga kapitalista, minsan bumababa rin yung mas lumiliit yung share na binibigay nila dun sa mga employees or sa workers. So minsan, the more na mas lumalaki yung profit, mas lumiliit yung pag-share. In terms of the workers, ang nakikita naman nilang perception, kapag ka mas dumadami yung benepisyo ng gobyerno, minsan, they tend to become relaxed. Kumbaga, mas hindi na sila nagtatrabaho, especially kung masyado silang satisfied sa mga nakukuha nilang benepisyo or sa mga nakukuha nilang incentive or sa sweldo. Which is very usual na nakikita ko in government. So, kumbaga, meron tayong mga nakikitang mga nagtatrabaho sa gobyerno na parang wala na silang interest to grow. Kumbaga, simula nung mahabang panahon na 10, 15 or 20 years, napako na sila sa ganong plantilla nasatisfy na sila sa kung ano yung kinalalagay nila at saka yung tinatanggap nila. So, they stop learning, they stop engaging sa mga trabaho, no? So, kumbaga, nasanay na sila na ganun. So, merong mga ganong may mga ganong trabahador na tayo na nakikita, na usually makikita natin to sa pamahalaan. So what can keep parties from negotiating? Parties, as mentioned earlier, negotiate because they want to satisfy a need or interest. So whether it is private or public sector, we usually negotiate because we want to satisfy a need or an interest. Planning the negotiation. First, we research the other parties to the negotiation. Second, we set the objectives. Third, we try to develop options and trade-offs. Fourth, we anticipate questions and objectives and prepare answers. Conducting the negotiation. In conducting the negotiation, one should develop rapport and focus on obstacles, not on the person. Let the other party make the first offer. Listen and ask questions to focus on meeting the other party's needs. Don't be too quick to give in, and remember to ask for something in return. So, kung dito makikita natin, this four represents different ways on managing, kung titignan natin, on managing conflict. So, ginagamit rin pala siya sa pagko-conduct ng negotiation. Collective bargaining, negotiating agreement. It is a specific and specialized type of negotiation governed by law. CBA or CNA is the law between the parties. It must be respected at all times. So, kumbaga, itong collective bargaining or collective negotiating is, kumbaga, agreement between two parties. Kumbaga, technically, employer tsaka employees union. So, here is an example of a collective bargaining agreement process. So, the negation, terms, conditions of employment, the mechanism to administer the agreement and resolve disputes or differences arising from it. So, kumbaga, dito inihahatad sa proseso. So, ang output nun is collective bargaining agreement for the private sector or a collective negotiation agreement for the public sector. So, ano yung outcome? What are usually the outcomes of CBA or CNA? Some of it are fair terms and conditions of employment, industrial peace and stability, increased productivity, effective employee participation, and shared responsibility. So sa collective bargaining or sa collective negotiation agreement, the agreements are two ways. So kumbaga hindi naman one-sided na papabor lang sa empleyado, hindi lang rin one-sided na papabor lang sa mga sa employer. So katulad sa atin sa sa government, isa sa mga basihan is kumbaga yung performance natin. Meron tayong merong minimum performance na hinahanap sa atin para makakuha tayo ng particular percentage of kung bonuses man yan or incentive based on the collective negotiating agreement. So I think that would be all for now. Thank you very much for listening.